next item on the agenda is a talk by Ms. Hasini Rathnamalala, lecturer. She is a lecturer at the Faculty of Law at the Sir John Puttara Defence University. Holds LLM degree from the University of Minnesota Law School, USA. LLM from the University of Colombo, Sri Lanka. LLB Honours, University of Colombo. Commissioner of Oaths, Company Secretary and Attorney at Law in the Supreme Court. I would like to make this the contribution at this stage.
Thank you, sir. Good morning, ladies and gentlemen. Today I am here to present my research paper. It's a comparative analysis on protecting women's human rights in conflict situations, that is Sri Lanka and Rwanda. In this introductory part, I would like to draw your attention on the reasons why I selected Rwanda for the comparative analysis. Here I am citing Adam Jones in Journal of Genocide Research. Here it says, rape was the rule and its absence is the exception. Rwanda's conflict expands the legal interpretations and legal considerations in international law, specifically on women's rights. Women in armed conflict and international tribunals such as International Criminal Tribunal for former International Criminal Tribunal for Rwanda, that is ICTR, and one of the main findings in the respective international legal domains is that sexual violence used as a weapon in war in Rwanda's context. When I come back to Sri Lankan conflict situation, Sri Lankan women's rights in conflict. Sri Lanka as a country currently in post-conflict situation or even ahead of, which assures there were less incidents of women's rights violations during the conflict. But some experts in the area of human rights and some country reports and human rights situation reports are in the view of that there were some women's rights violations during the Sri Lankan conflict. I would like to draw your attention for the objectives of this comparative analysis. Firstly, I wanted to comparatively analyze the status of women's rights in the context of armed conflict in Rwanda with the status of women's human rights during the internal armed conflict of Sri Lanka. Secondly, to discuss the widespread sexual violence as a weapon in Rwanda's conflict. Then I am to seek whether sexual violence used as a weapon in Sri Lankan conflict. When I come back to Rwanda's situation, there was a government involvement, right? Women were vulnerable party to all kind of sexual violence during the period of war. And Rwandan genocide was the mass propaganda against Hutu women, the minority women, Hutu women through the governmental media, right? Finally, not only the omissions by the government, chief government officers, but they also directed or indirectly they encouraged violators to carry out their brutal sexual violence campaign against Hutu women. Here I want to show you the difference in Sri Lankan situation. Sri Lankan armed conflict had different socio-economic and historical causes, different to Rwanda's situation. But it was also between the government and the rebel group, that was APT, that was alleged to be the representative of minority of the Sri Lanka in a particular area of the country. And when I coming back to the status of women's rights in Sri Lanka during the conflict, violations of rights due to the internal displacement were reported, right? But widespread, mass-scale sexual violence has never been reported in Sri Lankan conflict. I'm coming to the most important part of my research, the applicable legal framework. Here, when we discuss about the concept of women in war, international human rights law and international humanitarian law our jurisprudences are applicable. My research is mainly based on treaty-based mechanisms. Firstly, I want to draw your attention on the Committee on the Elimination of All Forms of Discrimination Against Women, which we know as CEDAW Committee. In its concluding observation in 1996 on Rwanda, it states, I'm quoting, the committee was dismayed at the deep psychological trauma, the unwanted pregnancies, and the massive rape of women and girls during the genocide. I want to draw your attention to these green colored lines, which resulted in widespread HIV/AIDS and other sexually transmitted diseases. This can of course eventually lead to further illness and death of thousands of women and girls, unquote. Secondly, there must be a witness protection unit in the War Crimes Prosecutor's Office to protect those who testify about rape, sexual violence and other crimes. Now my question is, do we have that kind of issues now? Now we are in the post-conflict situation. Do we have such issues? It's my question. That is what I am questioning through my research. International Criminal Tribunal for Rwanda. It was established by UN under the Security Council Resolution 955 of 18 November 1994. We know it as a very progressive development in international law and in international human rights law. Judges progressively and broadly interpreted the status in order to address the sexual violence occurred in Rwanda. It focused on providing criminal justice for women who faced atrocities during the conflict. But the main obstacle facing is that witness inhibition of providing evidence. Now I'm coming back to the Sri Lankan situation. Let's see what Women's Committee says about Sri Lanka. It says the committee remains deeply, I'm quoting, the committee remains deeply concerned about reports of gross violations of human rights of women on both sides, particularly the Tamil minority group, the internal displaced women and the female ex-combatants, unquote. Secondly, the committee is particularly concerned about the reports of sexual violence allegedly perpetrated also by the armed forces, the police and militant groups, unquote. Finally, the Women's Committee discusses in our concluding observation on Sri Lanka about internal displacement. Internal displacement is discussed in a lengthy manner rather than going to sexual violence. Also, I focused on other treaty-based committees' concluding observations on Sri Lanka. Committee on the Elimination of Racial Discrimination, the RACE Committee, Committee Against Torture, and Human Rights Committee on Sri Lanka. In their concluding reports on Sri Lanka, it neither mentions that sexual violence used as a weapon in war in Sri Lanka, nor it does contain any similar findings on sexual violence, rape, or other sexual violence crimes. No extensive allegations on women's rights violations in the conflict situation. On 3 of these committees' concluding observations, we cannot find that sexual violence used as a weapon in war. Now I am coming to the controversial Darusman report, the report of the Secretary General's Panel of Experts on Accountability in Sri Lanka 2011. We commonly know as Darusman report. The allegations on it were mainly based on highly controversial Channel 4 video, right? Allegations are directed to the government forces on the possible sexual violence and rape against LTTE women soldiers, right? I would like to draw your attention to this red highlight line. So, possible sexual violence, and finally it says violations of right to health against lactating mothers and violations of right of internally displaced women. Now I am coming to the conclusion. Here you can see the different situations in Rwanda and Sri Lanka. In Sri Lanka, first I come to Rwanda. Sexual violence used as a method of warfare in their genocidal rape, right? And there were incidents of internal displacement as well. When it comes to Sri Lanka, even the most controversial Darusman report has no mention that rape and sexual violence used as a weapon in war, right? No mention by UN treaty-based committees that sexual violence used as a weapon in war in Sri Lankan conflicts against Sri Lankan women or Tamil minority Sri Lankan women. But there were many instances and many places in which they discuss and they put fingers on us, on Sri Lanka, about internal displacement as a major women's rights violation during the Sri Lankan conflict. Thanks.